Donald Trump slams Jack Smith's attempts to destroy presidential immunity before it's even established. We know Donald Trump has been appealing this case that came out of Judge Chutkan's courtroom. Trump said, hey, you can't prosecute me and indict me for stuff that is within my job description as the president. If I'm out there speaking about a rigged election, then that's my job, because the executive doesn't want rigged elections to take place. Well, we know Judge Chutkan out of DC. She says, well, if we do that, America's going to die. And she said, sorry, Trump, your case does not get dismissed. So Trump submitted an appeal on this. And that's where we're currently at. Now, remember, for context, Jack Smith wanted to accelerate this appeal. And he also wanted to leapfrog this appeal by taking it to the Supreme Court of the United States. Supreme Court said, nah, there's no rush here. Why don't you just go on back down through the regular Court of Appeals and respond there? So on a prior video, we already reviewed Jack Smith's response to Trump. Trump said, I'm appealing because I've got immunity and double jeopardy, the two main issues. Jack Smith responded and said, if we give you that, then we're all going to die, because Donald Trump literally could just execute Congress. That was in his motion, not my words. The president could just execute Congress and then they wouldn't impeach him and stuff like that. Kind of psychopath stuff, but we're talking about Jack Smith. And so now this is Trump's final word. This is at the Court of Appeals. And this is the final layer of the sandwich before we get oral arguments, which are going to be taking place about 1 week from today. We'll be covering it, of course. But now this is Trump's final word before those oral arguments. It's 41 pages. We're going to hit the highlights. Case is United States of America versus Donald Trump on appeal. This is the reply brief from Trump out of the DC Circuit Court of Appeals on appeal from Chutkan's courtroom. Oral arguments scheduled. Mark those calendars for January 9th. And then this will be something that is going to be appealed going up to the Supreme Court. So we're making a record, and this will be a historic case. We get right into the summary of the argument from Trump's defense. They say, dear Court of Appeals, President Trump has immunity from prosecution for his official acts. And we're always comparing and contrasting these framings because Jack Smith says Donald Trump is arguing about absolute immunity so that he can just do whatever he wants. And, it's kind of a free-for-all, which was never Trump's argument. It was always much more circumscribed. They say, under our system of separation of powers, the executive power, the presidency, is exclusively vested in the president. Now, a president's official acts can, quote, never be examinable by the courts. That came back from a seminal case in American jurisprudence called Marbury versus Madison, arguably the most important case in American law, 1803. Because if this happened, if this case were decided that the courts can say that a president's act is examinable, then doesn't that make the court really the president? So it established this real interesting line that, oftentimes I think a lot of self-interested men at the time would not do. They want to give themselves more power, and that didn't happen here. So it's a very seminal case. That's why it's so important. Now we don't have any of that. Now we just have one political person prosecuting his enemy. So they say the judicial branch cannot issue equitable relief directly against the president's official act. So the court can't order something against the president, including his power under the take care clause. In other words, the president has an obligation to his duties. So also it cannot sit in criminal judgment over them. It's an extension of Marbury versus Madison. If the court can't examine the executive, then how can the court, through criminal law, now suddenly examine them? Because they just decided that president's conduct was criminal because Jack Smith and Joe Biden, ordered Merrick Garland to go get this done. They say the Constitution's text and history and policy support this conclusion. The impeachment judgment clause presupposes the existence of presidential criminal immunity. It's obvious. Early commentators, including Alexander Hamilton, James Madison, Chief Justice Marshall, Justice Story, ever heard of them? They support it. And they're supported by the 234-year unbroken tradition of not prosecuting presidents for official acts, despite vociferous calls to do so from across the political spectrum. Also provides powerful evidence of this. In the last 234 years, we didn't have anybody demented enough to do this because it wrecks everything. Now, analogous immunity doctrines, also rooted in the separation of powers, demonstrate the basis and the existence of criminal immunity for presidents. The likelihood of mushrooming politically motivated prosecutions, you mean like 4 of them? Yeah, probably like the ones we have like right now. Yeah. And future cycles of recrimination are far more menacing and crippling to the presidency than the threat of civil liability. And remember, we've already talked about this Nixon case. We've already established in the Supreme Court that there is presidential immunity for civil liability. So they're saying, if that's obviously something that's necessary to protect against that, this is obviously the next extension. Therefore, the scope of criminal immunity has to be at least as broad as civil immunity. For example, in other words, the outer perimeter of the president's official responsibilities. He can go all the way way to the maximum wingspan. He can capture it all in there. All 5 classes of conduct from Jack Smith in his indictment, everything that he put in the document that he says, this is criminal, all falls within the scope of the perimeter. Saying the impeachment judgment clause and principles of double jeopardy, they both independently on their own bar Jack Smith from bringing this prosecution. And the plain text of the clause, ordinary principles of interpretation, the decisive weight of the historical evidence, they all confirm that a president who was impeached and acquitted is not subject to additional prosecutions by deranged thugs. They say here, Court of Appeals, now the government came to you with their so-called statement of the case, which we read through. And they say that the government's statement of facts is both legally and factually incorrect. F. Thanks, Jack. F minus. Try it again. Now, the government attempts to emphasize the allegedly unlawful manner and purpose of the acts alleged in the indictment. However, assessing whether immunity applies, that's not what the courts do. The courts must look to the nature of the act itself. So Jack Smith is applying a different test. The improper manner or purpose is just not relevant under the law. Even worse, they say. So Jack Smith is picking a wrong test and he's trying to apply the wrong test because he's deranged. But even worse, the government relies on facts that are even outside of the indictment. Okay, the 4 corners of the documents, they all allege criminal conduct. That's what we charge on. If you want to say somebody's guilty of something, you got to put it in there so that we can know about it, so that we can get evidence about it, so that we can present our defenses to it, and so we can ask the jury to issue an opinion on this, guilty or not guilty on that one. So when you start bringing in a bunch of other stuff, you say like this person caused an insurrection, but you know, he also leaves the seat up at home too. Also, he does that too. And there was this one time when he didn't hold the door open for somebody. And like all of these other things, all irrelevant. It's all meaningless. Get out of here. You don't get to say all that stuff. Like, what can you prove? This is a court of law, not the View. All right. Here, even worse, they say they're using a bunch of stuff outside of the 4 corners to wrongfully suggest that Trump is responsible for the events at the Capitol. But they didn't charge him for those things. They say this is improper. The indictment does not charge President Trump with responsibility for the events at the Capitol. Like literally, like a fun statement, right? They're not even blaming him for the riots at the Capitol, is what Trump's defense is saying. Doesn't even charge him for that because these are like conspiracy to obstruct. Donald Trump talked with the DOJ. Conspiracy. Donald Trump talked to Mike Pence. Conspiracy. He talked to the alternative electors and all, alternate electors, blah, blah, all the things. But they're not even charging him with the J6 stuff. And so no evidence supports those allegations. Now, the government's account selectively omits key facts in their little narrative, such as this one. For example, in his speech at the Ellipse, President Trump encouraged the crowd to, quote, peacefully and patriotically make your voices heard. They left that one out. He also said, we want you to cheer on our brave senators and congressmen and women. And they left that one out. But I think that's coded language. That actually means execute Order 66. So President Trump denounced the destruction of the monuments and other symbols of American democracy. He never encouraged anyone to enter the Capitol. He said on social media that the protesters should remain peaceful and to, quote, stay peaceful. He released a video from the Rose Garden telling protesters to go home now. And the government's brief omits the vigorous disputes and the questions about the actual outcome of the election. Disputes that date back to November 2020 and continue to this day in our nation's political discourse. And more of the country is agreeing with us. It's trending our direction because people are asking themselves about this. Wait a minute. They said that Russians were responsible for that Hunter laptop. I thought Putin was responsible for that. And now Hunter Biden is taking a dookie right on the steps of Congress in front of James Comer saying, I'm innocent of everything. They said, wait a minute, what? So is there something there or is there not there, right? We're asking ourselves so they covered up the dirty baggage for their political opponent. And then people are realizing it. Okay, the facade is crumbling off. We all see the Biden crime family is corrupt and the media covered for them. The CIA covered for them. So they're based on extensive information of widespread fraud and irregularities. Yeah, like the CIA and like the FBI, Elvis Chan submitting reports to have channels censored. So they say, look, he said all of that and all of that got ignored because Jack Smith doesn't care. Now they say President Trump, by the way, has immunity from prosecution for his official acts. This is in the reply to the Court of Appeals. They say Article 2, Section 1 vests the executive power exclusively in the President of the United States. No prosecutor nor judge or jury may sit in judgment over the President's official acts, because that would be insane, because then that person would be the President. Every time that we say, well, the classified documents are not Trump's. I mean, wait a minute. So Congress can just pass some statute somewhere that says that these are classified documents? That doesn't override the President's power under the Constitution that's delegated to him. And if they could, that makes them more powerful than the president. That makes the FBI more powerful than the president. Or NARA. If Donald Trump has to fill out a form for Deborah, hey, Deb, can I have my documents? No, get out of here. What? Okay, thanks, President Deb. It's ridiculous. Same thing here. A president's official acts can never be examinable by the court. And when Liz Cheney was crying from her podium up there, whining about Trump should have done something else, that's not her prerogative. She doesn't get to substitute her judgment. She's not the president, never will be. She's not even in Congress anymore. Womp womp. So the government, they say, this is Jack Smith, they argue, they want to shatter like this historical precedent. They say, oh no, Marbury, seminal case, they say, it addressed the reviewability of acts of executive officers in general, but not the president in particular. So the president is excluded from that case. Now, Marbury distinguished an executive officer's ministerial duties from the president's officials act. So they say, by the Constitution of the United States, the president is invested with certain important political powers, from Marbury, in the exercise of which he is to use his own discretion and is accountable only to his country in his political character. And this is the point that the left fails to get. If the country really thinks that Donald Trump is an insurrectionist, we can just vote against him. Maybe they will. Okay, we're all going to go to the polls. Probably going to be him versus Biden. Maybe, I don't know. And when we get there, people can vote. And so if Liz Cheney and Adam Kinzinger have the better argument, great, then Trump will be held accountable by the people. But we don't shatter the country and openly allow criminal prosecutions against your political opponent to save the country. Like, we get that. The people are the ultimate check. Now, there exists and can exist no power to control that discretion. Being entrusted to the executive, the decision of the executive is conclusive. A subordinate officer is to conform precisely to the will of the president, and the acts of such an officer as an officer can never be examinable by the courts. Marbury. Really, you kind of set the entire tone of our jurisprudence. Jack Smith doesn't like it. Thus, the official acts of the president in italics, says Trump's team, can never be examinable by the courts. Why? Because the executive power is vested with him by the Constitution. Chief Justice Marshall emphasized that point in Marbury. Says nothing can be more perfectly clear than that. The president's acts are only politically examinable. And this is why I say that the president is like the root. The president is like the origin source of total power, because that's how the system functions. The logic of the system requires it to function that way. Otherwise, somebody else is more powerful than the president, even if it is some disgusting bureaucracy. We can't do that. It's by design. That's why it's an important and powerful position. Likewise, Justice Story also wrote about this. He said the president in his official acts is accountable only to his country and to his own conscience. His decision in relation to these powers is subject to no control, and his discretion when exercised is conclusive. Discretion. Like, this is all official duty stuff, right? Nobody's saying he can just like start nuking cities or something. So it says he reinforces this point. It is no answer that such a power may be abused. This is what they said. Oh my gosh. Well, if that's true, then the president can abuse his power. Okay, that's true, writes this smart judge, Justice Story. He says, yeah, there is no power which is not susceptible to abuse. And this is where demented Jack Smith went a little bit extra demented, even for our liking here. He was saying Trump could just execute like half of Congress. Okay, look, maybe in your deluded state. Yes, everything can go. You can pull on every string until it snaps. But that doesn't mean you just get to prosecute anybody on a whim because your side hates the other person. Now, the remedy for this, writes Justice Story, is to be found in the Constitution itself. It explains clearly, he writes, impeachment and Senate trial. Very easy. If there really is a big problem with the president, boom, impeach him and have him tried very quickly. They did it pretty quick with Trump. Justice Story rejected the notion that the legality of the orders of the president would depend not on his own judgment, but on the findings of facts upon the proof submitted to a jury. Right. I don't know if this was a good decision or not. Let's take it to court, and then we can let a jury decide whether that was criminal or not. I had to decide what to do right then and there. No, we don't run the country via criminal jury or Jack Smith. So they continued. They say, look, we're going to support this. Accordingly, we've got Mississippi versus Johnson. That says that courts may not issue an injunction against the president's official acts. The separation of powers says accordingly. And the government cites this case, but that case is inapplicable, not even on point. The government also cites the president's amenability to criminal subpoenas as evidence. Okay, they want this. They're saying, okay, look, the president can respond to criminal subpoenas for evidence. But Fitzgerald distinguished that. A criminal prosecution is far more intrusive because it exposes the president to liability himself. And if you want more evidence of this from our founding days, there was a convention when James Madison was there. And these were made in support of a motion to make the president impeachable punishable for offenses in office. Impeachment, okay, from Madison, not criminal prosecution. Says James Madison, many people say he's the father of the Constitution, kind of the major thinker and crafter of it, provides a principal check against the alleged presidential malfeasance. There it is, very clear. Impeachment, not criminal prosecution. Now, contrary to Jack Smith, the threat of future prosecution with its more severe stigma and penalties is even far more menacing than a civil lawsuit. The government says the president already faces this concern, but on the contrary, impeachment and conviction. Yeah, so here Jack says the impeachment judgment clause authorizes prosecution after impeachment and Senate conviction. Well, now on the contrary, they say on impeachment and conviction, it requires a broad consensus of senators and representatives across the country. It provides a powerful structural check against politically motivated prosecutions, which I couldn't agree more. If Trump had done something actually bad and he was actually guilty of this, of anything, or any president was, then both parties would say, okay, like that's enough. In American history, and you can take a look at, for example, George Santos. Maybe that's a good recent example. In American history, now, you know what's not a good example of that is Menendez, who also looks like maybe he's going through the process. Everybody's innocent until proven guilty. But, we'll see. We'll see what happens to him. We'll see what the Democrats do with him. Of course, they cover for their own. In American history, 3 presidents have been impeached and none convicted. None. Stripping away this check would radically diminish the president's independence, and people would come up with newfangled and artificial treasons by which violent factions would wreak havoc and turn their malignity upon another. Written by James Madison, Federalist 47. So they say the government is now citing OLC memos and other things. And they argue that the prospect of future criminal prosecution for knowingly criminal acts can have a salutary, not a chilling effect. Now they rely on the presumption, they say, ironically, the government relies on the presumption of prosecutorial regularity. But the prosecution of a president is necessarily and unavoidably political. So you can't just say it's like a regular criminal prosecution. Even the OLC is saying, if you're going to prosecute a president, it's going to be political, obviously, because we're not idiots. But Chutkan comes in and says, I didn't want to talk about the election. I don't care about politics. You're going to treat him like every other J6er. And those weren't political either, even though, of course, we know they were. So they say Jack Smith says that Article 3 courts, and we read this and we laughed about this yesterday, hysterical. He says, if a president is being unlawfully prosecuted, the Article 3 courts can just fix it. Like they won't let politicized prosecutions come through. Oh gosh. Hey, Jack, have you been to DC? And we made the mathematical arguments. What's the conviction rate for J6ers versus the DC local crime contingent? What's the difference? Both happen in Washington, DC. Is it 99% for J6ers get convicted? But what's the percentage of convictions for charges based on all the other crimes? Put them all together. DUIs, put them on domestic violences, drug crimes, pick them. What's the breakdown there? Obviously, it's biased and partisan, and the courts are rubber stamping it. They love it. They, go to cocktail parties, and we saw Judge Barrel was up there with Lisa Monaco doing whatever they were doing up there. Anyways, they say that the courts can just fix this. Well, that logic is circular, saying under the separation of powers, Article 3 courts cannot sit in judgment of the president's official acts, and the government cannot cure the unconstitutionality of that by invoking the aspect that is the most offensive of the separation of powers. That's the point, is you don't get to do that. And so Jack Smith, we can just solve that by just putting the courts in charge. Hello? That's the whole problem, is you trying to subordinate the president's official acts under some other entity, which violates the whole concept of separation of powers. So they say the government emphasizes the public interest in the federal criminal prosecutions. We have, people who are saying, we need a speedy outcome on this because justice delayed is justice denied. And that needs to get done now. And of course, we know that, the urgency here and really the framing of that is often for the defense, right? When you think about throwing somebody in custody for 5 years without prosecuting them, their justice is being delayed. That's on behalf of, generally the defendant. And the right to a speedy trial is often exercised on behalf of the defendant. We don't want the court to delay. But my point is, they're absolutely accelerating Trump's prosecution. They want to get him done in like 9 months with 14 million pages of discovery. And they say it's because of the people. Like, we need an outcome on this. Well, for the election, right? That's the point. So, but again, the government overlooks the great deterrence and the disruption to the president's functions from the threat of these prosecutions. And if you are now alleging that the president can be prosecuted for his official acts, it outweighs the government's interests here. The government says that criminal immunity would contradict the rule of law and that the president would be above the law, which is a dumb phrase because the president is. That's why they can pardon people. They say, I don't like that law. No thanks. Not so. But in this case, the Supreme Court explained that immunity does not entail that the official is above the law, whereas here, absolute immunity is essential for the conduct of the public business. The Constitution mandates immunity here, which is the most fundamental law. Now, the government government is also citing some other things, and they say that criminal immunity is sobering, and it would expose the nation to dangerous risks. They say, no, sorry, Jack. On the contrary, allowing a single prosecutor like you, who's illegally appointed, to sit in judgment over a president's official acts, that poses dangerous risks. The U.S. Senate, not the special counsel, has the constitutional authority and the political accountability and the institutional competence to determine whether the public interest justifies prosecuting a president for official acts. Not Jack Smith. He's not elected for anything, not appointed either or confirmed by the Senate at all. He's not acting on behalf of the people. He's acting on behalf of Joe Biden. So stop with the urgency for the public's interest. The Congress is structurally designed to consider and reflect the interest of the nation. That's the public interest. If there was enough constituency out there barking at the senators, convict Trump, they would have done it. That would have been the interest of the nation. But guess what? They didn't. There wasn't enough of that. Half the country, or maybe not half the country, but a good portion of it said that there's not enough there. And so there was not enough, the 2/3 requirement to actually convict him in the Senate. And so they failed. That is representation, all right? Not Jack Smith, who gets appointed by Merrick Garland. Now, as for the government's parade of hypotheticals that we read through and laughed at yesterday and at the prior in Jack Smith's reply, that Trump is going to execute Congress, like literally, that's his argument. The memo explains that concerns are addressed by the accountability of impeachment and removal. If they've engaged in serious criminal misconduct, easy. The Senate just convicts them. A president suspected of the most serious criminal wrong, or like Nixon, I'm out of here, might well face impeachment and removal before his term expired, permitting criminal prosecution at that point. Impeachment first, removal second. Now, the government's concern that the practical obstacles to impeachment, like Congress takes a long time, it might prevent the prosecution of a president in some marginal cases. It misapprehends the doctrine of separation of powers. These are called structural checks. That's why we have a trial before we lock someone up, because you don't just go fast because you're very angry at Donald Trump. Against the government, it creates similar risks of under-enforcement, but they ensure that we do not lose liberty, okay? The safeguards, the checks and balances requiring an impeachment and a conviction before some demented prosecutor who doesn't represent anybody decides they're going to try to deviate the entire course of the election. No thanks. We want it to slow down. We want those safeguards. Now here they say, also constitutional text supports the presidential immunity. The government is arguing through Jack Smith. They say, the Constitution doesn't expressly provide for executive immunity, but the Supreme Court recognized there is absolute immunity and qualified immunity for other executive branch officials, neither of which are in the Constitution. So that's interesting. If the Constitution doesn't expressly provide for it, so what? Supreme Court found it elsewhere. And there's a bunch of stuff that's not in the Constitution that they found in there. A lot of it, unfortunately, they found it, like Commerce Clause powers and so on. Now, some other rights are good. We have some right to privacy things that are in there too. Anyways, the text of the Constitution does explicitly acknowledge the president's criminal immunity. It does explicitly talk about it. Read the impeachment judgment clause. Jack. Next. In other words, that's the process for breaching the immunity. The president is immune unless this happens. Now, next, Jack Smith notes that impeachment applies only to high crimes and misdemeanors. Okay, but high crimes and misdemeanors encompasses official acts of the president that the Senate deems sufficiently serious to warrant removal. Things that are of a nature which may be peculiar with propriety be denominated political. Okay, so this is a quote from Federalist 68. They say, thus, in the Constitutional Convention, they thought the Senate, okay, was the most fit depository of this trust. The Senate does the trial, not the Supreme Court. They rejected the Supreme Court as the appropriate venue for the trial. Now, the government is saying Alexander Hamilton made some quotes that don't serve Trump's argument, but they say, no, Hamilton was well aware that the president could also leave office upon the expiration of his term. He made this point multiple times, right? So this is another argument. They say, Jack Smith says the president, he could commit a bunch of crimes and then leave office and they couldn't impeach him because he's not in office anymore and blah, blah, blah. They say the president of the United States would be liable to be impeached, tried, convicted. If he is convicted of treason, bribery, or other high crimes and misdemeanors, he's removed from office and would afterwards, after that, even after he's removed from office, right, then he's liable to prosecution. Now, they say Hamilton knew the president could leave office upon expiration of the term. Hamilton made the point multiple times in the preceding sentences, but he did not say that the president would be subject to prosecution for official acts after completing his term. The government also cites that, and the government cites this one, but that is for subordinate officers below the president. Now, below the president is below the president. Now, they're also citing some other things from some other sources, and they're also relying on the pardon of President Nixon. They say, the president, right, this is their argument, that presidents can be prosecuted because Nixon bailed. Nixon said, I'm about to be indicted or something, right? We don't know what he was going to do, but they say, okay, so he knew that he was going to be criminally charged. President Ford was pardoning him, and so that shows that the president can be prosecuted. And here, Jack Smith says, well, see, that's evidence that Trump can be prosecuted, even though Nixon was not prosecuted because he was pardoned, theoretically. Maybe he was not going to be prosecuted anyways, who knows? But of course, we said, okay, that was private conduct. It's outside of the official duties. So that doesn't apply, Jack. In any event, like the founders, President Ford emphasized the divisive nature of the prosecution of a former president. It's kind of an ugly thing. Shouldn't do it. And we're just going to put it to bed. Okay, so any other hacks out there back in the 1970s, 80s said that if you want to prosecute him, you can't. Sorry, we're not going to go down this ridiculous road. He said that criminal prosecution of the president would prolong the bad dreams that continue to reopen a chapter. And so he made the same judgment the founders made before this country got infested with liberal psychopaths. Says the criminal prosecution of a former president should not and could not fairly proceed in Article 3 courts. It's not set up for that. Now, analogous immunity doctrines also support this. The government says that legislative immunity is limited to legislative acts, but this parallels the scope of immunity claimed by Trump, all right? His claims of criminal immunity are for presidential acts. The government says that presidential immunity came back from successive British kings. And they say, well, this point also supports Trump. In our structure, official immunity reinforces the separation of powers. We separate them so one agency can't subordinate another agency. And then the people are really the ultimate check for those political questions. But preventing this, they say separation of powers shields the president, no less than the members of Congress, from scrutiny and hostility for official acts. Now, the government cites a bunch of cases, and here they get to this point. They say, look, this indictment violates presidential immunity. Jack Smith, he says that immunity might depend on the function that the president is performing. But we already rejected that in Fitzgerald. It would be difficult to determine the presidential function, and then you have some judge who's now determining whether that's legitimate or not. Now, the government says that immunity turns on the manner or the purpose of the president. And they say Trump wanted to rig the election or steal power, blah, blah, blah. They say no. Many cases hold that the purpose and manner is irrelevant to immunity. And they give a bunch of cases: Spalding, Barr, Georgier, Biddle, Pearson versus Ray, Fitzgerald, and others. And third, the prosecution suggests that under a case-by-case basis, but they say anyways, finally, the government suggests immunity would be overbroad, but the same logic applies here. Now, all of the acts from Trump, they all fall within the outer perimeter. Anything the government says is unconvincing here. They say that Trump made public statements that were supposedly knowingly false. And they say that's ridiculous, knowingly false. The government's empty assertion, that's utterly false. Punks, you think it's knowingly false? Well, you're utterly false. Illegal Jack. They say President Trump was carrying out his duties as the chief executive to investigate the overwhelming reports of widespread fraud, but nevertheless, absolute immunity would apply even if the statements were allegedly false, which were not the case. The government argues also that this is part of private actors. They say no, there's overwhelming involvement of official staff, and private actors only played a minor role. And so the impeachment clause also prohibits a new set of charges because we've got double jeopardy that attaches, saying the government's minimal historical evidence contrasts with our extensive evidence. We have more sources than you. They ignore much of what we've given you. What the government does is misapprehend Hamilton's statements. They say in his description of impeachment, Hamilton thrice indicated that prosecution follows Senate conviction. So per Hamilton, an acquittal means prosecution cannot proceed. So their double jeopardy analysis is also terrible. They say President Trump did not assume that the impeachment penalties and process are criminal in nature. We didn't assume that. We showed it. Impeachment was adapted from the English, which was criminal, included removal and disqualification. And so we suggest that removal and disqualification are criminal prosecutions. In fact, Blackstone thought so too. So did Hamilton. And so as we were going to say, they were going to, well, it's not double jeopardy because the first impeachment and trial was not really like a criminal proceeding. It's not like really bad. It's like kind of like a parking ticket. And so you can only have jeopardy when there's like a real thing that attaches, or you were placed in jeopardy. Like you could have gone to prison on this thing, man. You got acquitted though. Trump would be impeached and removed from office, right? Never to run again. Like that's pretty serious business. And then open to other criminal. So they say, well, it's not really a jeopardy. And they're saying, of course it is. We say the government says that it's not enough, but they say principles of double jeopardy apply to impeachment, even under the Fifth Amendment test. And so we're answering the government's analysis here. They say here, double jeopardy protections emanate from the impeachment clause. And while double jeopardy principles are relevant, the key is what will effectuate the constitutional constitutional purpose of the clause. And that requires dismissing the prosecution, because the prosecution, it undermines the Senate's judgment. The Senate already decided this on behalf of the people, our representative body, and they acquitted him. Sorry, Jack. So they say, therefore, Judge Chutkan's terrible order should be reversed. Love the filing from John Sauer on behalf of Donald Trump and other attorneys attached there, submitted into the DC Circuit Court of Appeals. And so this is the final word. We're going to now be back on January 9th. There will be oral arguments on this. The DC Circuit Court of Appeals will make a decision, and then very likely they're going to affirm portions of Judge Chutkan's decision. And I would imagine the prosecution is going to continue forward. Now we'll see what their ruling says and where Trump's team takes it from there. But let's get some reaction to this. Of course, the Biden White House, the people who were responsible for getting Jack Smith appointed in the first place, because Joe Biden was unhappy that Merrick Garland was dragging his feet and stopping Trump using the legitimate institutions of our power. And so they're now out hitting the same standard talking points. This is a Biden spokesperson. His name is Quentin Fulks. And he says that Republicans, like Trumpers, are literally, look at this, an existential threat to democracy. Joe Biden's going around on his insurrection anniversary tour, and he's going to be hitting this point that Trump tried to steal the country over and over again.
Why Valley Forge for Saturday? Are you expecting a cold winter?
No, we're expecting a very good winter come next November. But look, we chose Valley Forge. George Washington, as you just said, unionized colonies there and brought them all together. And then he became president and set the precedent for, a peaceful transition of power, something that Donald Trump and Republicans refused to do just as late as yesterday. And, we believe that they pose an existential threat to democracy. And over the last 4 years, that threat to democracy has only grown.
So what are you going to do if somebody is an existential threat to democracy? I mean, you can't let that person win, right? You have to prosecute them. You have to imprison them. You have to censor everybody who is supporting them. It's a new attack on the country, right? And we said this years ago, that Donald Trump is going to insurrect the country again, is going to be the new talking point. And that is a national security concern. As this escalates, it's a threat to democracy, right? That used to mean something significantly, wow, man, the terrorists are going to come and attack American democracy. We're all going to die. I know they still think that way. Many of us have waken up feeling duped by that whole thing, but this is the new thing, right? We're under attack. It's nothing but fear to motivate their base. They had the COVID, fear nonsense. They got climate change nonsense. They got abortion. They're stealing away your everything. And now it's insurrection season yet again. And it's going to be the whole thing in 2024. Now, I've got concerns about this because there are consequences to this, right? These people hold power. These are not just empty words from Karine. The FBI, the CIA, these are the people who might say, yeah, we have to stop this from happening to save American democracy. And this is the Biden White House out there with these ridiculous talking points. Now, here's a question. What happens if the Supreme Court does nothing about this? What happens if SCOTUS takes a look at what the Court of Appeals has done in the DC Circuit and says, yeah, that's pretty good enough for us. The case goes back down. We go back onto trial, and we may actually get a conviction. Maybe Judge Chutkan holds the March trial date. We don't even know. We'll see what happens. But this, of course, is Andrew Weissmann. He's a contributor over at MSNBC. He has a full podcast called Prosecuting Donald Trump. And we're going to listen to a small segment of it here. He's on with Mary McCord, and they're talking about this Jack Smith case. What's going to happen, guys?
And what Jack Smith had sought was to leapfrog the DC Circuit and go straight to the Supreme Court. The Supreme Court said no to that, at least for now. Doesn't mean they'll never take it up, but they said, we're denying that. I think in some ways that's because the DC Circuit moved so fast to schedule the briefing and argument that the Supreme Court probably thought, let's see what they could do. They might be able to avoid ever taking this if they end up just basically agreeing with what the DC Circuit did.
I just want to make sure everyone understands what Mary's saying is it is possible that the DC Circuit will issue its decision. I think by all accounts, it will hear this a week from today. It could rule very, very quickly. It is possible that the Supreme Court will take it. I think you and I both think it's probably likely they'll take it, but I think people should remember the Supreme Court could just say, you know what, we're going to leave it as is.
And what Jack Smith?
I don't think they're going to do that. I think that they're going to take it because this is a major issue, but they could. And, we're trying to speculate what could get this case back on track, right? Something like that could happen. Maybe it does happen, or I don't know. We'll see. So that's what they're talking about over on his podcast. Now, here's Christina Bobb, one of Trump's attorneys, also articulating her perspective on this, saying that the immunity provisions absolutely protect Trump from this criminal prosecution. Here's Miss Bobb.
Sure. The presidential immunity, I think that they should rule in favor of Donald Trump. Presidential immunity has been in play for the vast majority of our history. It's well established if the act committed, alleged in this indictment, are in the furtherance of his office in accordance with his political office, he's immune from prosecution. Clearly, clearly, as the president of the United States, he believes that there was fraud in the election, and he had a constitutional obligation to try to secure the election and figure out what was going on. So this is a very clear case. He should be covered by presidential immunity. I don't see them ruling differently, but we'll see how that all plays out. And then as far as the ballot selection goes, the case up from Colorado, I think that will be decisively in favor of keeping Trump on the ballot.
I think she's right about both those. And it's going to be very curious if the Supreme Court comes out and says, no, the president doesn't have any immunity for official acts. Because where are they going to draw the line? Like, is it only going to be official acts that are involved in insurrecting America? Like, what kind of rule are they going to craft? What is the limiting principle for the left on this? So there is no immunity for the president. So that means that we can prosecute Joe Biden. We can prosecute Obama for executing 2 American citizens without any due process of law. Is that fair game? Can we go after George Bush for lying us into 20 years of war? Is that fair game for all the presidents? I was like, okay, if we're going to go down this route, we're going to go down this route. And of course, the Supreme Court, I think, is going to have a lot more sense than these political partisan hacks. So we're going to be here continuing to cover this, my friends. Don't forget to check out watcherlodge.com to go check out our fitness challenge so that you can stay fit and fortified. We are still signing up. We've got until February 5th to get your 31 days in. We're on day 3 right now, and we're posting our fitness updates here. So come in, drop your fitness success in the comments at watcherlodge.com, and we'll see you over there. And of course, we'll be back here as well to dig into what's happening in the immunity case. We'll be back here for oral arguments as well on the 9th. And so we hope to see you. Thank you for subscribing wherever you're watching it. We'll look forward to seeing you on the next one.